أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم نحمده ونصلي على رسول الكريم. Last time we had left our discussion at the point of international wills. There are certain countries who have concluded a convention, an international convention, and some of them have ratified that draft, and people belonging to those countries can now use the international format of will that is that is called unidroit format. But one has to be careful to first ensure whether their country, his or her country, has already adopted it. From this, we'll go to today's lecture. But I think last time there were two more points which I think I had not covered. I don't know, perhaps they were missed. One is called the concurrent will. Right in the beginning, I said that the title, the name of the document, legal document, name of the legal document is Will and Testament. And will is for the property, estate property particularly, and testament is for money. So these two wills can be combined, and usually we say will and testament, but uh, in many jurisdictions, some people or many people prefer to make two wills, one separately for the property and the other separately for the money, for the cash, for the bank account. So these two set together, uh, made together, they are also called concurrent wills. Otherwise, they can be called will and testament. And then there is another kind of will that is contingent. For example, one wants to make a will, but he is not certain about something. There can be different conditions, different situations for different people. So he can put a condition. So contingent or conditional will is a will with a clause, a separate clause is added to the will. If the predefined condition occurs, then the will take effect, otherwise not. If the predefined condition doesn't happen, the will is considered invalid. So if one wants to make a conditional will, one can. And then, although we had discussed a separate type of will, but it is related to that will basically. One of our participants had raised a question about mirror will or identical will. In the same category, there is another will that is called mutual wills. Husband and wife, particularly, or maybe two separate persons. Two separate persons are, as an example, husband and wife, they can make mutual wills. Mutual wills are made between two or more people. It is general, where if one person passes away, the other person gets to own the latter's assets, and it is mutual. They make separate wills, but they make mutually beneficial for each other. Now we come to today's lecture. In the background of international will, which we had discussed, since there are people, as I know some of them who have properties in America, in England, in Canada, in the Western Hemisphere, and at the same time they have some properties in the countries in the Eastern Hemisphere also. But I will try to cover only a couple of those important countries. In England and Wales, now this is very, very important. The point which we are going to discuss right now. In England and Wales, marriage will automatically revoke a will. If somebody has made a will and after making the will, he gets married or she gets married, the will which he or she has made is revoked. So be careful. For example, somebody has made a will for the grandchild, and now the wife has died or something has happened, and he's going for another marriage. and after the marriage, he just forgets about the will which he had made earlier for the children, for the grandchildren. So the will which has been made before marriage gets revoked automatically after the marriage. But in case of divorce, it is totally different. It's the reverse. Divorce conversely will not revoke a will. If somebody divorces and he has made a will during the marriage time, that will not be revoked because of the divorce. He might think that I have divorced the wife, now the wife has no right on me, but it is not revoked. But in many jurisdictions, and one has to be careful to know the situation in each jurisdiction, but in many jurisdictions will have the effect that the former spouse is treated as if she had died before the testator and so will not benefit. In some jurisdictions, it will not benefit. But in some jurisdictions, even if the divorce takes place, if the will is made during marriage and the divorce is taken place afterwards, the will take effect. That divorcee wife or husband, he or she will get the benefit which was recorded in the will. So these are not ordinary points. These are very important points. One must understand these points. This is also very important, which we are going to discuss now. Election against will. This is in fact Islamic. This is Quranic. But since some Muslims, I would say, although I think majority of the Muslims are violating the provisions of Quran, but let me be on the safe side and say that some Muslims are very openly violating the provisions of Quran and Sunnah, the injunctions of Islam. Against election against will, what is that? For example, if a will has been made in which the person has given a certain portion which is completely correct, which is absolutely right, and according to law, according to Islam, he has allotted, he has made certain portion separately for the wife. But after the death, if the wife demands that she is not taking that amount, if it is in cash, for example, or some other property, she says, no, I will not take that. In lieu of that, I'm going to take the house. She has the choice. I'll read this out for you because be careful in this regard. In United States, and this provision is very Islamic, in United States, many states have probate statutes that permit surviving spouse to choose to receive a particular share. For example, a house, I have given an example. A particular share of deceased spouse's estate in lieu of the specified share, for example, cash, left to him or her under the will. Example, under Iowa law, the will which expressly devises marital home to someone other than the surviving wife. In Islam also, if the house is given to somebody else and not to the wife, you cannot expel the wife from the house, even though it has not been given in the will, and even though she is not entitled to get in the share as a share, because her share is less. But she decides, no, I will not leave the house. I'm going to live in this house. You cannot expel her from the house as long as she's alive, or she goes to marry some other person, or she, out of her own free will, leaves the house. This is Islamic law, and this is American law. Under the Iowa law, the will which expressly devises marital home to someone other than surviving spouse, the surviving spouse may elect, may select, may opt to live in the home for remainder of her lifetime. This is called life estate and terminates immediately upon surviving spouse's death. but people don't know. In many cases, they don't know these provisions of law. These statutes were enacted to prevent the deceased spouse from leaving the survivor wife or husband as a destitute. Law does not want the spouse after the death of one partner to go destitute. And this is the position in Islam also. After testator has died, application for probate may be made in court with probate jurisdiction to determine validity of wills and to appoint executor. Wife or anybody, even mother can go, sister can go, daughter can go to the court for probate. Intestacy is a condition of the state of a person who dies without leaving in force valid will or other binding declaration. And in that case, we had seen that the property, the estate, technical term is estate, will go to the government. That is called estate. Estate will happen, the property will go to the government. Now, since there are most of the participants are from India and some from Pakistan, so I have brought position from these two countries particularly. Muslims are governed by their own personal laws in India. Muslims are governed by Muslim personal laws. Document of will be clearly prepared so that it provides control over your legacy. It can be handwritten or typed on plain paper in India. There is no legal requirement to use stamp paper. Almost in Pakistan also there's the same situation, same. So it applies to both India and Pakistan. But if there is a difference, I'll tell them. Any language can be used. Hindi, English, Urdu, Sindhi, any language. The wording must be clear and unambiguous to prevent misinterpretation. If any question of constitution arises, you know that the original constitution of India is preserved in two languages, in Hindi and English. And whenever there is any question on interpretation, these two languages are brought together, two translations, not two translations, but two versions, or we can say versions are brought together. And you also might be knowing that when this Indian constitution was passed, it was preserved like a mummy. And they had sought help from Egypt. And these original documents of Indian constitution were mummified. Taxidermy had taken place in Egypt for both the languages, Hindi and English. If you think that somebody is wrongly interpreting Hindi, then you can take support from the English version. If you think that the English version is being wrongly interpreted, you can take help from the Hindi version. It should explicitly state that it is your last will and testament. But if you make two wills separately and testament separately, we have just discussed the concurrent wills. Testator must sign it or affix thumb imprint. In India, thumb imprint is allowed. You can use a thumb imprint because the rate of literacy is still not 100%. You can use the thumb impression. It must be indicated that testator is of sound mind with no sign of illness. This is extremely important. Hazar al-Maut, one is not in the state of Hazar al-Maut. It is not he is not in the state of death. He is of at least or she at least of 21 years of age and understands the nature of the actions. And he or she has the intent to make that will, that I intend to make this will. A will can be challenged and deemed void if fraud, coercion, or undue influence is proved. In India, most of the cases on will are taking place on these issues like that the person was ill, and where they bring this point, if the person dies within 1 year after making the will, they somehow bring it to the court that the person died within 1 year, and that was the estate of Hazar al Maut, and he had written that will during the estate of Hazar al Maut. So you have to be very careful about these things. And then they also bring these cases, right or wrong, on the charges of fraud or undue influence. Undue influence is very common. For example, when the will is being written and it is proved that the person had made a will under the undue influence of wife, or he had made the will under undue influence of the brother or father or mother. Then in families, if they if they can prove it, or even if it is wrong, they bring the evidence, they try to convince the court, then the complications arise. Detailed, comprehensive inventory of all the assets. I have used this, I have highlighted this comprehensive inventory. Includes movable properties such as bank accounts, stocks, mutual funds, jewelry, and vehicles, as well as immovable properties like land and buildings. Clearly identifying your beneficiaries involves listing full legal names and your relationships to each person. Now here, legal name, and not only legal name, but full legal name. And not only full legal name, but legal name with exactly, absolutely exactly the same spelling in which it has been recorded in the database of the country's national identity. These are small things, but these are very important things. It has happened to me because of just a very minor appearance of a dot, which was interpreted as a apostrophe. Although there was neither apostrophe in the name and there was not a dot in the name, but still it somehow in typing in the computer, in the ink, or somehow it appeared. And that was made the point to challenge it. Apostrophe. But in the name there was no apostrophe. Executor, he has to be trustworthy individual or institution. We had already discussed this. And in order to be on the safe side, you can also appoint an alternate executor. If the number one executor is not available, as in the case of witnesses in Ayat 282 of Surah Al-Baqarah, the other executor will step in. He can execute the will, but the court will authorize. Guardianship for minors. You can, in the will, appoint the guardian for your minors in the will. I'm repeating, in the will. One can appoint guardians for minor children in his or her will, providing care for them after his or her death. In absence of a named guardian, if the name of the guardian is not mentioned in the will, and the children are minor, and Quran has also exhorted that if you are worried about your children, you must prepare for those circumstances now. Appoint a guardian. The attention has been invited. If it has not been named, then minors may be placed in state care or with someone they might not have preferred, because the court will decide. The property and the person of the child can be placed under different guardians or the same guardian, which may not be beneficial for the children or it may not be suitable for them. A procedural requirement, although it is called a procedural requirement, but it is a legal requirement. Because why it is a legal requirement? Because the procedure has been provided in the law. It's something has been provided in the law, even if it is procedural, it is law. A procedural requirement for valid will is its attestation by at least two witnesses in India. You need two witnesses. Witnesses must see. If the witness comes to the court and say that yes, they told me that he had signed it. Yes, I was sitting in the other room, he signed it. Yes, I was sitting there on the chair, and while there were many people, they had covered the table. He was sitting on the table, he was writing there, and I could see that he was signing papers, but he doesn't say that every word, everything which is written there, it was read or it was written, and it was signed personally by the testator. Because the attorney will put a lot of questions to prove that he was not witnessing it. Witnessing is seeing, eyewitness. A procedural requirement is of two witnesses, and witnesses must see the testator sign or affix his or mark to the will. Add his mark, thumb impression, for example. If he is not, or if she is not, she cannot sign. She cannot read or write. Or see another person sign it in the testator's presence and by their direction. If the testator, situations can be there. Quran has also explained that position. If he cannot write because of any reason, the testator cannot write. He can dictate. The witness has to testify that the testator asked such and such persons, and the such and such person willingly started taking the dictation, and he was dictating, he was writing, and I was listening, I was hearing, I was seeing, and when he completed, the person who had taken the dictation, he read it out, and the testator said, yes, this is what I have dictated. God forbid, if the case goes to the court, all these points, and these are not ordinary points, and not only these points, but hundreds of points, more points come up, and the attorneys try to win the case. Each side tries to win the case. So one has to be very careful. Afterward, the witnesses must sign the will in the presence of the testator. Very minor thing, but very important. Sometimes a question may be raised in the court, not in one session, after so many sessions, after so many days, they ask the witness that when you sign the paper, the testator has put the date, say 1st of September, and when you have signed this, you have put the date 2nd of September. It means you were not there when the testator has signed it. Therefore, the entire will is invalid, entire evidence invalid. And there can be so many other points. While a beneficiary can act as a witness, this also point was raised for discussion, any bequest made to that witness or their spouse will be void. Kindly note this. Although it is allowed, but it can be void. Therefore, if you kindly recall, I had suggested that although it is allowed, but I don't recommend this, because there are many cases in which it has been challenged and it has been voided. Registration of the will in India is important. Though optional, registration enhances authenticity. I have explained one point. Why do we register? We register because it has been provided in the law. It has been written. And then it has been said it is optional. Yes, it is optional. But anything which has been provided in the law, it is legal. It is a legal requirement. So it is better. If it is better, then one must take the benefit of it. It can be waived. It is not mandatory, only in circumstances that it could not be registered. For example, will was made, it was notarized, the person wanted to register it, but he died. There the argument will be that the registration was not mandatory. It's not necessary. Therefore, this will not be the point for discussion. But if there were all the facilities available, one could register, then it is better to register. Registration procedure, here some people make mistakes. Registration procedure involves presence of testator, presence of testator at the time of registration. For example, when you go to deposit the will in Houston, the clerk of the county, he asks you, are you the person who has written this will? He will ask you the question. And witnesses should be present with proof of identity before sub-registrar. Here in India, it is called sub-registrar. In Pakistan, it is called sub-registrar. Then that sub-registrar or registrar, original will is kept in safe custody with the registered. The registered or original will is kept in safe custody with registrar's office. This many people forget. Either don't obtain or they misplace it. Receipt must be obtained. I have highlighted this. Receipt must be obtained. For a codicil, if you are making any change in the will, it is called codicil. For a codicil to be valid, for a codicil to be valid, it must be executed with the same legal formalities as the original will. What is that? Then the person who is making it, if he has written it in his hand, he should make it in his own hand. He should sign it again at that point. He should put a date. If he has used the thumb impression, he should put the thumb impression. It should be witnessed also. Same formalities for the codicil. Legislations governing wills in India. These are two main documents. For Muslims, it is basically Succession Act 1913. Actually, Succession Act 1913 is the starting point of Islamization of law in the Indian subcontinent during the British Raj, during the British time. And it happened because of the movement of women, Muslim women. They had demanded that under the British law, under the Indian law, the women are not getting their due right of inheritance, due share of inheritance. So as a result of that movement, a Muslim movement, the new act was passed, Succession Act 1913, and the Islamization process of law in the Indian subcontinent started. This is a very important point in the history of Muslim law in the Indian subcontinent. Then Registration Act 1908. Registration of a will after death. Now, note this point, after death, the death has taken place and if somebody wants to register it, because the probate will take some time or there may be other circumstances, but still it can be and it is better if it was not registered to register. Registering a will after death of testator is essential step which requires death certificate, probate, second point. In any case, one has to go for probate, but in the case of death, one will take the death certificate also. File petition, and in the petition, the documents will be original will written by the deceased, death certificate, affidavit of the executor. This is an additional document. A list of the testator's assets, court fees have to be paid, and then the probate must be obtained. Without that, there will be no further proceedings. Time limit for registration of the will after death, although there is no time limit, but it is better if any 1 day more is delayed, there can be legal questions for challenging it. Will registration online. In India, it is allowed online. One can register. It is only for registration. All other things are the same. Only for registration, it can be online. In Pakistan, inheritance law is a fundamental aspect of family law in Pakistan. Family law. It is part of family law, not a separate thing. Key principles are, you will already know that, and I will not go into those details. Immediate transfer of ownership on the basis of the inheritance certificate, on the basis of the share which has been given in the inheritance certificate. For example, a widow, she can get the property transferred directly in her name. If it is in the will, on the basis of that, if the probate is allowed, she can do that. So these are very important things. Inheritance for orphan, guardianship, children. I've mentioned a little bit about it. I'm going to close the discussion on this today. Strengthened rights for female heirs. Clear documentation requirements. Here I had said that women, mother, daughter, wife, now they have more clear rights. They can go to the court and get their share, due share. Then online inheritance claim, she can file, or anybody can file the inheritance claim online. Filing for succession certificate online or in the court. Obtaining letters of administration if the administrator is appointed in the will, or if it is not appointed, the court will appoint. Court verification process will take place. Property valuation and tax clearance, this will be obtained, and one has to provide. Now, this is very time consuming. All these points, if you take care of when you are alive yourself, then this will save the survivors from a lot of hassle. And we have seen in many cases that the survivors, they don't get their share because of these procedures. So kindly be careful about your legacy, create a legacy, and complete the formalities. Subhana rabbika rabbil izzat amma yasifun wa salamun ala al-mursaleen walhamdulillahi rabbil alameen.
اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه. اللهم اهدنا فيمن هديت وعافنا فيمن عافيت وتولنا فيمن توليت وبارك اللهم لنا فيما أعطيت وقنا واصرف عنا شر ما قضيت فإنك يا ربنا تقضي بالحق ولا يقضى عليك. اللهم ادخلنا برحمتك في عبادك الصالحين. اللهم اخرجنا من ظلمات الجهل والوهم إلى نور العلم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما. اللهم اجعلنا ممن يستمعون القول فيتبعون أحسنه. اللهم اكفنا بحلالك عن حرامك وبطاعتك عن معصيتك وبفضلك عمن سواك. اللهم بفضلك ورحمتك أعلي كلمة الحق والدين. اللهم انصر الإسلام وعز المسلمين يا أكرم الأكرمين. Oh Allah, spread your mercy upon us. Shower us with your blessings. Increase our knowledge, grant us forgiveness, and reward us with the company of the prophets in the Firdaus al-A'la. Oh Allah, purify our hearts, strengthen our faith, increase our knowledge, and make us benefit from what you have taught us. Oh Allah, forgive our parents and all our friends and relatives who have passed away. Oh Allah, make their graves garden from heaven and grant them the Firdaus al-A'la. Oh Allah, we have many of our friends and relatives who are sick. Oh Allah, grant to all of them full and speedy recovery. Oh Allah, guide our children, protect them, and make them righteous. Oh Allah, grant us the power and the ability that we may be grateful for the favors you have bestowed upon us and our parent, and that we may do righteous deeds that are pleasing to you. Oh Allah, we seek from you all of the good, whether we know it or we don't. And we seek your refuge from all evil, whether we know it or we don't. Oh Allah, we seek refuge in you from incapacity, from laziness, from fear, from greed, from poverty, and from the torment of the grave. Oh Allah, we have many of our brethren who are living under oppression and injustice. Oh Allah, heal their trauma, protect their helpless, and grant them lasting peace and prosperities. Oh Allah, we ask with every name you have elected for yourself, that none of us leave this gathering, but his pains have been relieved, his worries have been removed, his debts have been paid, His weaknesses have been concealed, his sins have been forgiven, and his needs have been fulfilled. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. وآخر دعوانا أن الحمد لله رب العالمين، والصلاة والسلام على خير المرسلين. اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه، والسلام عليكم ورحمة الله وبركاته.